Hey there, welcome back. All right. Today we're going to be talking about chapter 19. This is going to be lecture 6. This is the protection of liberty, property, and equality by Richard Epstein. And it's sort of, I don't know, it's a little bit of a controversial article. And even at the end, he's like, I don't even believe in the minimum wage, which I kind of find silly. But yeah, we're gonna focus on just the first part of the chapter and sort of skip part two. Um, and his main point here is that we need to have a clear cut level of judicial review for all types of cases when um, government overreach is being considered. But when I read the chapter, what I really liked about it was sort of his approach to the judicial process and explaining sort of judicial review, and then his overview of freedom of speech and equality of the law. Um, and so we'll talk about some important court cases and we'll talk about those more than we'll talk about sort of the economic side. Okay, so he basically in the introduction says, there's obvious decisions to be made about liberty versus sort of protection of property rights in society, right? And that the ideal state is one that doesn't act without producing some sort of social benefit, and also to no individual cost, right? Which is obviously very difficult to do. This is the ideal, right? So a constitution is obviously necessary. And he first starts out by saying that, a socialist constitution that promises everyone, food and a job and housing and that sort of thing wouldn't work um, because it sort of destroys the market system. This guy's very, very pro market, right? And so he says a constitution is necessary, and the U.S. Constitution is a good example of what should be set up, right? Because from the very beginning, it sort of institutes checks and balances, different branches that are important to ensure that you limit government, right? And so I already have a little bit of a problem with this thesis, right? Because judicial review wasn't actually established in the original Constitution. It was established in Marbury v. Madison in 1812, I believe. So, that's what, 25 years after the Constitution was signed. Um, so even there's a little bit of an argument. But, he says the early Constitution at least um, had limited government, had checks and balances, and that sort of achieving a strong government that also sort of, I don't know, disinhibits rent seeking behavior by politicians and the rest, um, needs three things. It needs the protection of liberty, it needs the protection of property, and it needs to choose a standard for judicial review, right? Um, and so there's really three ways to look at it, at least in the American context: strict scrutiny, rational basis scrutiny, and intermediate scrutiny, right? So strict scrutiny is the most protection against government overreach. Rational basis standard would be the least, right? And so we've used these three different approaches. And he suggests that the more strict it is, the more likely a statute will be struck down, right? Um, and there's three approaches to the judicial approach. Uh, when a court has confidence in the legislative or administrative process, it's likely to defer to their judgment. When the court thinks that a certain class of claimants, especially those individuals found in discrete and insular minorities, are unable to protect their interests in the political process, then they will receive greater protection than others. And then third, the constitutional rights that are essential to sort of maintaining the democratic process in particular will receive greater scrutiny than others as well. And then he says, okay, we're gonna basically my argument here is that some cases like speech and race cases get a higher standard of scrutiny than do economic and property cases, and that the government has more power in economic and property case legislation in restricting behaviors, um, putting a restriction on the number of hours that employees can work, um, putting in a minimum wage, things like that. Um, that the court should have a stricter standard when it comes to those kind of cases. Okay. Despite that, what I want to talk to you about is sort of just part one, right? And so he talks first about freedom of speech and that the court has very strong protections for speech, right? And so it's good to just know a sort of basic history of your rights through the courts, right? And so the clear and imminent danger sort of became the very strict scrutiny that the government had to prove to police speech. And this occurred in 1969. And this is the idea that uh, speech has to be sort of causing actual malice, actual immediate harm to an individual or to a group or threaten property. So if you're, saying, go burn that house down, or go kill those people, or go beat those people up, um, that's a crime. Otherwise, regardless of how sort of obnoxious it is, or just sort of socially gross, right? Like, really openly misogynistic or maybe racist, like sort of white power groups or Nazis, that kind of thing. That kind of thing. It's still okay so long as they're not inciting violence or threatening property, right? Um, Defamation, when it comes to either the newspapers or news organizations or even individuals, um, you have to cause, um, you have to have printed or said the information with actual malice and knowing that the statement is either false or was so sort of reckless with the truth that it could easily be proved wrong, right? So this was sort of the approach when they sued Alex Jones for, pretending that the shooting, I think it was in Massachusetts, that killed dozens of little kids, elementary kids, was fake and was like a government fake operation. And, a lot of like political weirdos came out and threatened those people. And so, yeah, he lost a crap load of money. Um, Oh yeah, another good example recently is Rudy Giuliani, right? He made false statements about um, these two election workers in Georgia, and posted about them and posted on social media and claimed that they had like faked the election and won the election for Biden in Georgia, and they got come after by a whole bunch of people, and it got pretty ugly, and um, the courts decided he had to pay, hundreds of millions of dollars in recompense. So that guy's going to be bankrupt forever. Um, and then moving on to sort of art and symbolic speech, the court has been very strongly in favor of the public, even if it's sort of obscene or even if it's burning the flag. It's still legal because it's seen as either symbolic speech or artistic expression. And the only sort of limit on that is, of course, for children. You can't have pornographic or violent sort of things for children. And then we'll move to equal protection of the law. I would actually like you to know a few of these court cases for the exam. So the first one we'll talk about is Brown v. Board, right? There was the decision in Plessy v. Ferguson in 1896, which said that segregation was legal. Under the Constitution, I think it was like, a quarter black man tried to get on a train, and they tried to, tell him that he had to sit in a black car. He refused, and the court said that he has no right to refuse, and that the states do have, I guess, an interest in public health and elsewhere to separate the races. But in 1954, in Brown v. Board of Education, um, the the Supreme Court used the Equal Protection Amendment of the 14th Amendment, the Equal Protection Clause of the 14th Amendment, to overturn Plessy v. Ferguson, and say that, all citizens have the right, to all public services, regardless of race. So two very important cases, Plessy v. Ferguson and Brown versus Board, which overturned it. Again, these are based on the 14th Amendment. Okay, Loving v. Virginia, again, used the 14th Amendment. This was a 1967 law in Virginia. The law was overturned, which said that black people can't marry white people. It's called an anti-miscegenation law. Miscegenation is, right, this idea that people of different races shouldn't get married. And so the Supreme Court in 1967 banned anti-miscegenation laws in Loving v. Virginia. Okay, in Grutter v. Bollinger in 2003, the Supreme Court upholds Michigan's standard for affirmative action in their education and university systems, and says that the state does have an interest in diversifying their universities, because this helps with the quality of the university and the education. But then in 2023, just last year, Students for Fair Admission versus Harvard and the University of North Carolina, the Supreme Court overturned the former rulings that upheld affirmative action. So there were a string of rulings, with first in Michigan with Grutter v. Bollinger, but also the University of Texas and some of the University of California systems, schools. But they were all struck down basically in this new ruling in 2023, Fair Admission versus Harvard. Um, um, Now, equal protections, he makes this point, and it should be made. Equal protections tend to be weaker when it comes to gender, right? Because the court does not see gender as the same sort of minority in the sense that they see race in the U.S. courts. So, I think, what was the quote? Man, well, oh, here it is. Okay, the quote is, "When the court thinks that certain classes of claimants, namely those individuals found in discrete and insular minorities, and are unable to protect their interests in the political process." So I guess the argument is that women are not a minority in the numerical sense that racial minorities are, and so they treat them differently under the Equal Protection Act. All right, that's all I've got for you. Thanks for participating. Get involved with those court cases. They're very important court cases in U.S. history. So thanks for being here. Have a great day.